Jack Gotti's lawyer Doug Weinstein, along with other lawyers in the Apt law firm, have filed an emergency petition for writs of mandamus and stay of proceedings. To dumb this down, they're basically asking to pause the case and ask the Supreme Court of Georgia to step in and mandate that Judge Glanville refers this motion of recusal to another judge. Let me know if you guys want this shirt on the screen right now. I think it's pretty funny because this shit's corrupt as hell, and a portion of the profits will be going towards a charity in Atlanta. Comment down below any good charities. Let's get into this video. All right, boys, here's the full document right here. Diamante Kendrick's emergency petition for writs of mandamus and stay of proceedings. Weinstein, Katie Hingerty, J. App. This document has a table of contents. So there's no way I'm going to be able to read all of this, but I'm going to try to get the gist of everything. Jurisdiction and explanation of emergency nature petition. This emergency petition concerns allegations of serious breaches of the Georgia Code of Judicial Conduct that violate petitioner's state and federal constitutional rights. This petition relates to conduct of Chief Judge Glanville and not to any rulings or orders of the judge. In the case at bar, original relief in the form of motions for recusal have been filed and denied 3 times by 3 respective movants. Glanville's denied the movants' respective requests for a certificate of immediate review 3 times. We all know Glanville's been showing some signs of corruption from the get-go here. Glanville, as chief judge, has obstructed the defense counsel's attempts to have a disinterested party review the numerous allegations contain at least 4 affidavits which allege judicial misconduct and unfair proceedings. These affidavits, if true, would constitute serious violations of the Code of Judicial Ethics. Citing a lack of evidentiary foundation caused by Glanville's own recalcitrance and refusing to provide a transcript of a secret ex parte proceeding. Glanville has hindered defense counsel's ability to effectively pursue relief by claiming judicial privilege while denying certificates of immediate review. Assuming this court would not get the opportunity to review the decisions on multiple motions to recuse unless or until the underlying case was concluded. Glanville continues to hide behind a purported standard that his actions will be reviewed in the hindsight for abuse of discretion. Glanville has always been saying, we'll just see what happens in appellate courts, instead of just fixing the problem right then and there. Glanville's obstruction of defendants' right to a fair and impartial trial has risen to a level that defense counsel now believes all attempts to obtain relief in the Superior Court of Fulton County will be ineffective. Oh boy, here we go. 3 motions for recusal have been filed and denied. 2 writs of mandamus are already attached to the instant case, which were filed and pending for more than about 1 year. Therefore, any effort to follow a writ of mandamus in Fulton County that would be heard by the judge would result in frustration and lack of action. Glanville's court is where writs go to die. Oh, that's a good one-liner right there. As the present petition for writ of mandamus will go to Glanville filed in Fulton County Superior Court, petitioner has no other option than for the Georgia Supreme Court to exercise its discretion and consider its defendant's claims. So they wanted to go straight to Georgia Supreme Court, obviously because Glanville's denying anything and everything. And now they talk about the ex parte meeting that we already know between Kenneth Copeland, Love, Hilton, and investigators from Fulton County DA's office. And we also found out from Miss Bumpus, Kenneth Copeland's lawyer, that apparently there was like 13 or 14 people in this room. Despite preceding all requirements of Uniform Superior Court Rule 25, the motion for recusal was denied without following the required procedure of USCR 25.3. Glanville holds a unique position within the county which carries a significant amount of weight and power among his fellow county judges. Glanville has repeatedly refused to issue a certificate of immediate review that would permit the Georgia Court of Appeals to review his decision on the recusal motion. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. The appellate procedure in that case will be extremely lengthy and cumbersome, with more than a year's worth of transcripts to review. This is extremely up. I mean, these guys are going to be in jail for years waiting for all this to be handled, if it goes to appellate courts, which I have a feeling it will. Emergency relief is requested because the witness that was coerced by Glanville is presently on the witness stand. Remember, Judge Glanville coerced Kenneth Copeland to testify because he threatened him with years of waiting in jail. Absent emergency relief from this court in some form, Glanville will control the scope and substance of undersigned counsel's cross-examination of Copeland. Brady material that counsel believes but not provided to counsel as required by law, as well as the coercive joints of the bench and state. Petitioner requests this court grant a writ directing Glanville to adhere to Rule 25.3 and thus assign the motion for recusal for hearing before an unbiased judge. Petitioner further asks of this court that proceedings in the trial be stayed pending and resolution of the motion for recusal. So they're asking for the trial to be paused so that Supreme Court of Georgia can figure all this out. Petitioner further asks this court for a writ ordering Glanville to produce immediately and certainly no later than prior to the start of cross of Copeland an unredacted transcript to the defendants of a secret ex parte proceeding held on June 12th. If I remember correctly, 2 days ago, Glanville said he was going to give transcript to the defense. So now they talk about the ex parte meeting again, where Woody, a known snitch, was threatened with jail time and basically changed his mind to testify. Sworn witness Copeland also stated to Hilton that he would testify and that he killed Donovan Thomas Jr. Important Brady material that is yet to be provided to Kendrick. So yeah, they never handed that over to defense, which is exculpatory Brady evidence for the defense. These troubling facts not only implicate Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Attorney Kayla Bumpus, by and through her counsel, filed a motion to quash the order to show cause and motion to recuse. At 8:30 in the morning, Mr. Copeland and his lawyer, attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte proceeding. Once Copeland learned that he could be held indefinitely by Glanville if he refused to testify, not just 2 years as he initially believed, Copeland yielded. Unreal. Absolute travesty. Brian Steele, on behalf of all the defense counsel, specifically asked Glanville about the reasons for delay, providing Glanville an opportunity to reveal that an ex parte proceeding had occurred and the content of the proceeding. Failing to provide any substantive response, Glanville obstructed Steele's attempt to discover a reason for the delay. Glanville denied Doug Weinstein's motion and Brian Steele's motion for recusal. Weinstein requested at the time a certificate of immediate review. That request was also denied, foreclosing any opportunity to appeal Glanville's ruling. Glanville stated that an appeals court could look at it, which would take years. Standards for granting writs of mandamus. To compel removal of a judge, a petitioner for mandamus must show that a sufficient motion to recuse has been filed and that the motion has not been denied after assignment to a separate judge. To preclude mandamus, the alternative legal remedy must be equally convenient, complete, and beneficial to the petitioner. They cite Blaylock v. Cartwright. Glanville has failed to follow the rules on the recusal and has violated multiple rules of Georgia Code of Judicial Conduct. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, which he said it was timely, whether the affidavit is legally sufficient, he said it wasn't legally sufficient, and whether the affidavit sets forth facts that if proved would warrant the assigned judge's recusal from the case. Glanville failed to follow USCR 25.3. Glanville denied the motion, relying on a mischaracterization of the Weinstein affidavit as a complaint about a ruling made by the court instead of recognizing it as a list of incidents of judicial misconduct. So yeah, he was basically saying these are just complaints of rulings. These aren't even anything I did wrong. There's no blame for me here, boys. He likes to say the word assertions. That's your assertion. That doesn't mean it's true. Judge Glanville, if you threatened a witness years of jail time, that's coercion. And said witness admitted to killing someone, that's Brady evidence. Point blank, period. Glanville curiously clings to Baptiste v. State, 1997, as supporting his contention that the Weinstein affidavit does not merit recusal. But there's no support in Baptiste for this position. In fact, Baptiste supports the petitioner's position that Glanville's bias is of such nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. So the judge keeps talking about Baptiste v. State, but apparently in that case, it's the exact opposite, and it actually supports the defense side. Glanville's order of June 14th contains a critical error of law. The law requires that when making a determination under USCR 25.3, the court must consider whether recusal would be warranted, assuming any and all facts in the alleged affidavit to be true. A judge is not allowed to pass on the truth of the allegations in the affidavit. Instead, Glanville properly found that Weinstein's affidavit contains assertions of fact to support the allegations of bias and partiality. By law, should have ended his inquiry. Glanville must then give it to another judge. What a shocker. Judge Glanville ignoring USCR 25.3. No big deal here, boys. Glanville's factual review of the Weinstein affidavit is particularly astounding, given that Glanville's repeatedly refused to give defense counsel access to a transcript of the secret ex parte proceeding. It is apparent that Glanville has made every effort to keep the proceeding a secret and inaccessible to defense counsel, going so far as to hold Steele in criminal contempt for refusing to provide the name of our source and to issue an order to show cause to attorney Kayla Bumpus in an attempt to silence her. Attempting to silence Woody's lawyer, they assumed that it was her that leaked it to the defense. While Glanville's views appear to be evolving over time, Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. However, at this point, Glanville is still indicating that any transcript provided will be redacted to remove privileged information. Why are you redacting shit, Judge Glanville? That's so sketchy. What if the key parts of the goddamn ex parte meeting are just blacked out? What type of corrupt shit is this, dude? What could be privileged in a proceeding among Chief Judge Glanville, the prosecution, sworn witness Copeland, and Copeland's attorney is a mystery. The facts alleged in Weinstein affidavit must be assumed to be true. This violates Kendrick's rights to due process and a fair trial. Point blank and period. Not only did Glanville fail to notify defense counsel about the ex parte proceeding, as required by Rule 2.9, but Glanville made every effort to conceal the proceeding. I've read 2.11 a few times that judges should disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. Furthermore, Judge Glanville should not have coerced sworn witness to testify. A trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. And they cite Wynn v. State, Benton v. State, so he did that, like straight up. He coerced Kenneth Copeland to testify. Defendants were not provided notice of the hearing. didn't even fucking know it happened until the only logical conclusion for the secret nature of the proceeding was to give Glanville, in conjunction with the state, the unfettered ability to harass and intimidate the sworn witness into testifying. I mean, that's kind of what it points to, right, boys? Conclusion. Glanville's actions offend public confidence in the independence, integrity, and impartiality of the judiciary. An appearance of impropriety and bias hangs over the present trial due to Glanville. Here we have a judge who has failed to abide a provision of the Code of Judicial Conduct designed to ensure fair hearing, who has also actively attempted to conceal a proceeding. In my opinion, to a reasonable degree of legal certainty, this conduct legitimately calls into question the judge's impartiality, and assuming it to be true would require recusal. I don't see how the Supreme Court of Georgia doesn't grant this. I mean, this is going to happen. So this trial might be over in the next week or two. I don't know how long this is going to take, but Fulton County has this up so badly. Everyone deserves a fair trial, and all signs are pointing to this being corrupt. So yeah, I'm going to put this shirt up for sale pretty soon, and a portion of the profits will go to a charity in Atlanta. Hit subscribe. Love you guys. Peace out.